right, everybody, we are live. I know we've got two I see in the house, but we're going to get started because we've got a somewhat of an emergency live broadcast here, sort of. Yesterday, the Treehouse prosecutors filed a motion in limine, and they're trying their business again. This is what they did to Ty Tucker in the lead up to the last trial. And in the lead up to the last trial, nobody was paying attention, so they got away with it. They got away with stuff like what they've done right now. So they're not going to this time. So I need your help in spreading this video, getting people to become aware of exactly what the prosecutors have done here. And since we've all watched the trial, when I go over this information, everyone's going to know, that what they're saying isn't true because it's just flat out not true. But they're trying to misrepresent things. They're trying to turn this judge on Ty Tucker. We're not going to let him do it. At least we're not going to let him do it silently. So without further ado, we're going to jump into this motion in limine. It's only 5 pages. We're going to discuss it, go over it, and then go over the truth of the matter, and then go from there. So let's jump in here. All right, guys. So we have the motion in limine here. So here is the motion in limine. This basically a motion in limine is essentially it's a motion where the state can ask during trial to limit or keep things out, and they used this in the last trial with Ty very successfully to try to keep certain things out. Certain things are being mentioned, again, all of that was being done. Ty Tucker was under a gag order. Nobody knew anything about this thing because it was a silent thing that was happening. The press wasn't involved. So, but now people can see this now unfold in their eyes, and we're going to bring light to it, so that hopefully other people that have a bigger footprint and a bigger ability to reach people can get this out and can be as upset as we are when the state is trying this stuff. Anyways, let's get into reading this thing. So, motion for order in limine, evidence tampering, comes now. Dennis Ward, Assistant State Attorney of the 16th Judicial Circuit of Florida, by and through the undersigned Assistant State Attorney, and moves this honorable court for an order in limine instructing the defendant to refrain from making any direct or indirect mention whatsoever at trial before the jury of the matters herein set forth, without first obtaining permission from the court outside the presence and or the hearing of the jury, on the grounds that the said matters are incompetent, irrelevant, or immaterial to the issues involved herein, and will serve only to unfairly prejudice the jurors against the state. The subject matter in question are the following. Now, I want you to look at this here. 1. During the first trial, the defendant alluded to the court that it was his belief that evidence in his case had been tampered with and attempted to mention this during trial. First of all, this is the first issue. He never, ever said anything was tampered with. What he said was mishandled, and that is exactly what the IA report is. And you're going to look at the exhibit they put up and put forth, and hopefully when Ty responds to this, I hope he goes forward and sets the record straight. This is why we need in fact, what they've done here in this motion has now, I would say, requires the entire record. What the prosecution has done here is the judge in the last hearing said, well, I'm not sure we're entitled to a whole record. Now there's other motions they filed where they basically said, we don't need the transcript to the entire case. But we're just settled for John Travis Johnson and Tyrone Tucker's testimony. Well, I think in this motion, the fact that they're misrepresenting what's happening here, Ty Tucker needs to make issue of this. He needs to research what Florida cases are available, and I would maybe do a little research myself to see if I can find something. But he and his attorneys need to research and figure out, look, if a prosecutor is misrepresenting the situation or the trial, and he needs to go back. I mean, I've got to go back. I haven't had a chance. I just wanted to bring this right out, but we need to go back and look at the moments, but it's easier to do with a transcript, but yeah, and the transcript is technically evidence, as Mansfield has said, is the only thing you can use for impeachment or to contradict things. But this now, the state and what they're trying to do here by misrepresenting things that occurred in the trial have now made it clear that this case can't move forward without a transcript. And that would be the next one of the motions I would be filing is, obviously, and then on top of that, prosecutorial misconduct, outright prosecutorial misconduct, that we need a transcript for that purpose. Of course, there's also the motion to dismiss over due process issues. But we have a situation here where the state is openly lying to the bar and taking advantage of the fact that this transcript doesn't exist. So that cannot go uncontested here with the state trying to do stuff like this. But this is what they're trying to do. And the thing is, remember, this is a guy that they know is innocent. So what they're trying to do here is misrepresent this to the judge, make it look to the judge like Ty Tucker was suggesting that evidence had been tampered with and that that's what this is about. What they're trying to do is reframe the argument, because it's that report, that IA report, was not about tampered evidence. It was about mishandled evidence. And mishandled evidence followed the failure to follow chain of custody, which is what was being alleged and cross-examined to Detective Malone, is absolutely relevant. And it is not prejudicial to the jury because it absolutely goes to the trustworthiness of the investigation and everything that emanates out of the investigation. Unlike what Judge Jones said when he said the trial's not about the investigation, it's about evidence emanating from the investigation. Absolutely not. Ty Tucker has to get out in front of this right now and file his own motion in limine. Well, I don't even know if that would be the particular deal here, but he needs to file in response here to clarify that that is not what this was being used for. And the only way to settle this, since there's an open dispute, by filing that is to make a motion and request and renew a motion for the full transcription now at the cost of the court, because the state has raised this issue. So either they back off this issue or we're going to delay the trial until the entire transcript is available and we can review that transcript and the judge can review that transcript, because the only way the judge can decide if Ty Tucker contests this is if the entire proceeding is reviewed to see how Ty Tucker used this. So it can't go forward now. The prosecution is anticipating that Ty Tucker wouldn't know how to respond to this motion, but he's got to respond to it that way. And respond to it with the request that now, judge, and go find case law that supports the fact that if you have a case that's already been in the trial and the state is misrepresenting things that happened during that trial and it's asking for the court to take action on that, there's only one way it can move forward. That is a full transcription of the trial so that the judge can read it, become familiar with it, and understand the context to which all of this occurred and things that were said. That's the only way you can have it, because what they're saying happened did not happen in the case. So during the first trial, the defendant alluded to the court that it was his belief that evidence in his case had been tampered with and attempted to mention it during the trial. That is not what happened. 2, when asked by the court what evidence he had to substantiate his belief, the defendant claimed that Tom Walker, former MCSO who was tasked with evaluating the investigation of the case for internal affairs, had a list of evidence in the case and he wanted to ask him questions about his findings. The defendant never provided this list to the court nor the state. The defense was not permitted to make any reference to his subjective belief regarding tampered evidence. Now, here's the problem. This is a complete misrepresentation of what occurred, okay? Because what occurred was he was attempting to enter the internal affairs investigation that Mr. Walker had done, and he was attempting to enter it during the cross-examination of Detective Malone. He wasn't allowed to enter the report, but he was allowed to question her about the report. Now, there's a big difference there, because if that report gets in front of the jury can view that entire report and see that one of the lead investigators, in fact, the investigator, which is a very relevant matter, that the very investigator who completed the arrest affidavit, who completed the probable cause affidavit, was censured by IA, not just censured, but relocated by IA to a different department, not because of her not being able to deal with being a police officer due to her personal affairs, but because she essentially mishandled evidence in this case and others. Now, that report wasn't able to get in because he needed to call a custodian of records, and maybe that's Tom Walker. I'm not sure if that's who that is, but he needed to call a custodian of records to get a business record hearsay exception, which he wasn't sure how to do, and he didn't do that. And as a result, the judge was able to keep it out. Now, the judge could have done the correct thing that you do with a pro se defendant that is unfamiliar with the rules of evidence, unfamiliar with the law, and said, hey, Mr. Tucker, I know what you're trying to do here. So this is what you're going to need to do, sir. Here's the steps. Maybe this judge will do that because that's proper procedure. Now, if Mr. Tucker fails to do those steps in a timely fashion, now he's waived the right to have that happen. But the fact that they didn't even tell him about how it should be done or how to get it in, knowing he's a pro se defendant, and basically use the fact that, hey, we've restricted your ability to have access to any attorneys or advisors who could have also told him how to get it in. Guess what? It didn't happen. And as a result, they weren't able to get Tom Walker in. They weren't, and subpoenas ran out, and the whole deal just absolutely imploded on itself. But at no point was he saying something was tampered with. He was saying that he wanted to get put forth the list of evidence in this case that had been mishandled. And we're going to go over the mishandling of that evidence. This should absolutely be in front of the jury because chain of custody is an important aspect with physical evidence and certain physical evidence. And the way things were handled in this case, the detective should absolutely have been able to have been cross-examined and questioned as to why she did certain things and what was the reason for this. And to see the incompetence and then to understand that that's who the jury has to rely on, an incompetent detective who didn't follow procedures. That is absolutely goes straight to the heart and the bearing of this case and goes straight to the heart to the bearing of whether or not you can trust beyond a reasonable doubt the state's case. So the state here is trying to redefine this and say, well, it's an issue of evidence tampering. Well, there isn't evidence tampering. He can never prove evidence tampering, and they know that. So it's imperative that Ty Tucker has to absolutely, in his response, that he has to reframe this. But the prosecutors are actively lying to the court about the circumstances, and they're doing it, and we're going to look at, I'll show you what else they filed, and they're doing it wide open. It's so egregious. And they're doing it while requesting that there isn't any, that they don't want any more transcripts done, that they only want the transcripts for impeachment of Tyrone Tucker and John Travis Johnson. Well, Ty Tucker now has a right to file to have the entirety of, they just put their foot in their mouth. They're going to have to wait. It's going to have to be transcribed. And maybe we don't have a trial before November of 2024. Maybe we don't have a trial in 2024 at all, depending on how long that transcript takes. And then going through this motion and figuring out things like this. Unless, of course, the state wants to retract this motion and admit that they lied in it. But at this point, they went forward with it. They own this. All right, 3. The state has now obtained a copy of the list the defendant was referring to and has attached it as Exhibit 1. It was in court. The whole report was put in. This list was already put in court. It was already put in a record. They act like they just obtained it and went somewhere. They have totally misrepresented the entirety of the situation. And the way to clear it up is let this judge, and I guess he could watch it and go back on court TV, but is that going to be record? Is that going to be able to be produced as part of a record and an exhibit to put with the motion, the response here? And I don't know that it is. It is clear from the spreadsheet that there are no references to any of the evidence being tampered with. Moreover, Tom Walker's report does not contain any allegations of finding that any of the evidence have been tampered with. More specifically, none of the evidence as it pertains to this defendant. That wasn't what was mishandled and tampered are two different things, and they're playing games with words here. And they're misrepresenting to the court what he said. And it was never a tampered issue. Okay. There are no references on there because that's not what Tom Walker said. He said it was mishandled and procedure wasn't followed. It was stored in inappropriate places, and the chain of custody wasn't followed in terms of where you're supposed to store that evidence and keep it and know where it's at so that you don't have any question as to what happened to that evidence in between it coming into the police station and going out for testing. 5, there being no evidence to support the defendant's position, the state seeks an order from this court instructing the defendant to refrain from any direct or indirect mention of evidence tampering. Wherefore, the state of Florida does hereby request that this honorable court grant the state's motion. Now, there's no problem with granting that, but Ty Tucker needs to make sure that it's very clear to the judge that this is not what was said at trial, that evidence tampering was not what was being alleged, that it was evidence mishandling in the storage, inappropriate storage of evidence that they were later intending to use in the case against Tyrone Tucker. And this, the failure to follow procedure, the failure to do these things is absolutely relevant to the case. And what they're trying to do is side door this to keep it out so that if he tries to bring up that report, they're saying, well, motion in limine's already been ruled on, Your Honor. It's about evidence tampering. And this judge won't look into it. Now, this judge, I can't believe hasn't looked into it, but maybe he hasn't. He's got a full docket. So this is where Ty Tucker has to fully respond to this motion, lay everything out, and request that the judge review the transcript to address the issue here that the state is essentially asserting something that never actually happened. And unless this judge wants to sit and watch the entire trial, which I guess he could do, which isn't an official record recognized by the state of Florida, so I don't know that he could even do that and then rule on this. So you've got to have a transcript. And Ty Tucker's got to come back, make that request, and make it clear he wants a transcript. And now the state has put everyone in a position that a transcript is the only way, is the only thing that would allow this case to continue to move forward. Now, let's look at the pieces of evidence. Let's look at what they said here, right? And let's see whether or not this fits with what Ty Tucker actually said, which is it was about mishandling evidence or tampering with evidence. And really, you can almost say tampering, it brings up the potential possibility that you can't rule out tampering. You can't say it wasn't tampered with because it wasn't stored properly. So tampering, it doesn't even rule that out. The jury would be allowed to consider that, and there should be case law. He's got to come up with case law on the idea that if you don't properly, in this case here, that why would he be precluded from suggesting or allowing the jury to infer that or suggest, because the whole purpose of having the chain of custody of evidence is to confirm it isn't tampered with, to confirm it isn't destroyed in any way or isn't affected in any way before it gets to the lab. So we have here, these are the pieces of evidence. We're going to go through each one and read it out because they put it in the record. We're going to put it in the record. So first thing is shirt with blood, shorts with blood, clothes taken from the decedent at the hospital, drying room. Question, where were these items for 13 days? Where were they? Were they being tampered with? Were they being mishandled? At a very minimum, they were being mishandled. This is the Internal Affairs Department. Why would this not be relevant in a case? The state is trying to misrepresent what happened here or what was alleged to have happened here. That's at the top of the page. Matthew Pitcher, transport to property control. What about suspect transfer DNA? Was there a supplemental report? Okay, we get down here to the cellular, LG in a gray case. Where was this phone from 11/21 until 1/19/18? Hello? All right, mishandling of evidence. Where was it? This phone was removed from property for HSI download on 10/10/18. When was the phone picked up from HSI? Where is the HSI download report for this phone? Where was this phone from when it was picked up at HSI until 11/26/19? Was there a supplemental report? This is called mishandling. This is called it doesn't suggest anything was tampered with, but it certainly suggests it was mishandled and not stored, and that there was questions about all of this evidence. Now, the thing is, they're not necessarily putting forth this evidence into trial, so I guess that it would allow for an argument to be made of whether or not you could put all of it in. But I think it speaks to the overall actions of the police here, and what were they doing with the evidence? Why were they taking things out? Why did they not follow procedures? And the jury's allowed to consider all of this. So for the state to try this disingenuous attempt to try to act like this is about evidence tampering, when it's about evidence mishandling, it's about not storing things correctly, it's about not following procedures, and the only reason this didn't come in was because the judge successfully was able to keep Ty Tucker from understanding how to get it in. But he's going to understand how to get it in this time, because I'm sure he's working with his advisors. I'm sure he's heard my feedback on things. I'm quite certain he's going to get this in next time. But the thing is, we have to deal with the fact that the state is lying about this. So we have now cellular LG black and green case. Who is BS 5473? Where was this phone from 11/21 until 1/19/18? Um, look at this, pocket knives. This is the murder weapon, I believe. Where were these knives from 1/22/17 until 1/19/18? Storage returned to owner. Items taken from Tucker when arrested. Okay, so that was stuff that was taken from Tucker. We've got belt with possible blood spatter. The belt was taken from Tucker's personal property at the time of his arrest. Lab testing and storage. Where was this item from 11/22 until 1/19? Was the possible blood spatter tested? If there's a possible blood spatter, did they not test it? You know, what the heck? Or did they test it and not like the results? 2 cellular phones, a Samsung and an Alcatel, 2 external drives, 7 micro SIM cards, a computer cord, an HP computer. Where were these items from 11/22 until 1/19? Clothes Franklin Tucker was wearing at time of arrest. Where were these clothes from 11/22 until 1/19? Knife and sheath, DVD with picture of knife on sheath. Where were these from 11/22? Crown Royal bag, marijuana pipe, can of pepper spray. Where were these items? Sandals, black sweater, wallet, flashlight, fingernail clippers, Florida driver's license, 2 pocket knives. They were recovered from him at the time of his arrest. Where were these items from 11/22 until 12/28/17? And where was there a supplemental report completed? Look, the issue here is mishandling of the evidence, storage of the evidence. It turns out this stuff was being stored in Danielle Malone's office. That's incompetence. That's evidence, especially if there's blood evidence. One of the reasons why that blood evidence couldn't be tested was because why? Well, because or that splatter that was on the belt. Why couldn't that be tested? Well, that's because guess what? It was stored inappropriately and they knew they couldn't bring it in because they broke the chain of custody. So they didn't even try. That would be my thought. Watch, jewelry, DVD containing photos of Bonnet's clothing and Ruget's shirt. Items recovered from Franklin Tucker at his arrest from the homicide that occurred on 11/17 and a DVD of photos of Bonnet's clothing and Ruget's shirt. Where were these items from 11/22 until 12/29, and was their supplemental report completed? The buccal swab of John Travis Johnson. Where was this item from 11/22 until 12/1? Was there a supplemental report? Cellular phones, Samsung, Alcatel, 2 external drives, 2 micro SIMs, and computer power cords. These were items of Tucker's. What was the date of Tucker's arrest? Were there any of these items taken for download? If so, where is the report? Where were these items 11/22 until 1/19? Was there a supplemental report? Fingernail clippings from victims' left and right hands, victim's DNA card. What were the FDLE results of this item, and was a supplemental report completed? So again, these apparently were not tested, I guess. Again, these are questions that the jury absolutely should be looking into because these were raised from the IA investigation. They didn't follow procedures and protocols. Correct. There isn't an allegation of tampering, but the issue is tampering could have occurred. And tampering could have occurred because we don't know where the items were. So it's a fair assumption based on the idea when you get, of course, the detectives should be allowed to explain it, but the jury should be able to allow to consider this, have this in front of them, and should be able to be entered as evidence. At least now, again, there might be a limitation based on what evidence the state puts in. So that might be a problem, but it should be allowed to be entered at some level, especially if anything is being used, like, we have the or at least question in detail, the buccal swab from Paula Bellamont. Why was this evidence taken on this date? Where is the FDLE report? Was there a supplemental report? DNA extracts from subs 1, 2, and 3. Where is the FDLE report? Those are things you might not want to be questioning about, but the missing items, where were these items? Why were they not put there? That's a question. And she might say, well, I don't know. Were you responsible? Who's the one that took them? Well, it looks like Detective Pitcher was discovered by Detective Pitcher. So one of the issues that we had in the last trial was Detective Pitcher's lack of presence. Well, he's going to have to be brought in this time because this report to deal with this fact. Now, but what I would be saying is he can be brought in after you question Malone, and she says, well, I can't speak to these items unless Danielle Malone, which I believe Danielle Malone had all those items in her office, if I'm not mistaken. But the point is, there's no allegations. He did not say this report was evidence tampering. He said it was evidence mishandling and failure to follow procedures. And you see here, Detective Malone, oral swab of Franklin Tucker, oral swab of Rory Hank Wilson entered into property. Where's the FDL report on these items? Where's the supplemental report? Farley Reel, Black and Clore, small backpack receipts. But this is where you could bring in, again, the individual that did this investigation and have him talk about these items and the problems that were occurred, that the evidence was mishandled, procedures weren't followed, and to me, that would be something that he has an absolute right to bring up to the jury. But the idea that the state wants to cover this up and act like, well, he said evidence tampering. It's not what he said at all. It's not what he said at all. DVD in front of CVS photos. Now think about this right here. DVD containing video of the drive-through CVS. DVD containing photos of Bellamont's injuries. Tucker. DVD containing 911 and CAD. DVD containing CVS video. Sims cards containing Metro PCS video. Where were these items 12/5 to 12/28? Was there a supplemental report completed? And where were these items 7/10 until 7/17/19? And I do believe some of those videos ended up missing and are not able to. So on top of that, if any of those would have had a clear view, okay, this should come in for a multitude of reasons. One, you have the Osakalumi case, which I've talked about, which is a West Virginia case, but it can be applied in Florida, which provides for which I could try to do that. Which provides for the hold on here. Let me get. We have a request here to make myself a little bigger here. There we go. So the Osakalumi case, as I had talked about previously, is a case that provides that in the event that exculpatory or evidence that's potentially exculpatory to the defendant gets lost and is in possession of the police, then you have the right to ask for a corrective instruction to the jury that if this could have provided, in other words, if the CVS video could have shown that Ty Tucker was not the man at the CVS and was not the second guy, and that they could see could have seen a clear view of when he pulls that mask off as Todd O'Quinn testified, then you are entitled to an instruction that says the fact that the police lost that evidence, does not get to benefit them, that they should assume and presume that the evidence would have been favorable to the defendant. In other words, it would have proven that Ty Tucker was not the individual. And the reason why they get that is because the state had possession of this evidence, reviewed this evidence, and then lost the evidence. So as a result, they don't get the benefit from the loss of that evidence. So in this case here, if any of these were lost, and I do believe the CBS tapes were lost, then this report also goes for that purpose. And that's allowed to be brought in. And that should be allowed to be brought up in terms of questioning Detective Malone, because it looks like it was Detective Malone who had all those things. Then you have 2 cellular phones. It looks like the same thing here. Items taken from Tucker. Where were the phones on 7/19? So, and then we have Malone, Phelps, Underwood, and Hoverson. Digital scale, Acura model, digital scale, pro scale, model slick wood box, pipes inside, Glad Tupper containers with seeds, round green containers, black case. 3 bottles. It looks like this must have been a cash bond receipt, a black cool pad smartphone, and bond receipt signed by John Johnson. Where were these items from 12/8 until I guess 12/17, 17, and was there a supplemental report? And then we have the cell phones again. Again, these continue to come up missing. Where were these items from 7/10 until 7/17, and was there a supplemental report? So the point here is that Mr. Tucker had a right to bring this forth to the jury not because it was tampering, which he never alleged. He never said it was for tampering purposes. And in fact, give me a moment, and I will see if I can locate quickly that section. I know what day of trial it was, but I'm not certain I'll be able to pull it up. Tucker, let's see here, and we'll see Franklin Tucker trial. I believe it was day 2. Trying to locate it here. I'm not sure if I'm going to be able to, but I think I've got it. Let's see here. I got yes. Let's see here. I'm trying to. I believe it might be, and maybe it might be the next day, or it might have been the end of day discussion. Okay, here we go. All right, I think I may have found it here. Let's take a look here. And we'll see if this is in fact, this is courtesy of Law and Crime, everybody, but we'll see if this is in fact, speed through this here.
Lunch, hope I appreciate it.
You said you are no longer a detective, no longer.
I believe this is where we get into it right here.
Correct.
Okay, and what department do you work in now?
I still work for the sheriff's office. I work in the 911 center.
Okay, is that a civilian position or is that a batch position?
It's a civilian position.
Okay, and how did you come to be in that position?
I requested to go into dispatch.
Okay, do you recognize this?
Here's the report right here.
State seen the document?
It's impeachment.
Well, regardless.
May we approach?
Yes.
So, and maybe there were things said in sidebar too that we didn't hear, but let's see if they make a record once we get up here. We're good. Sidebar.
Approach the witness. Get seated and then you may approach the witness.
And that is another reason why the tape here would not be good enough. So this is another reason why if what they're alleging was said as far as regarding the evidence tampering and everything of that nature, if that was said in sidebar conferences, then there needs to be the production of the transcript so that the judge can read those sidebars and decide Was this said?
A letter of recommendation from, I believe it was Major Shibuya, that I no longer be a major crimes detective.
Okay. Now, you just testified that this move down to dispatch was voluntary, correct?
It was, yes.
Okay. But Major Scabilia is your boss, correct?
He's the boss of pretty much everybody at the sheriff's office, yes.
Okay. And in this letter, he's making a recommendation that what?
That I not be a detective, but I still was going to be a cop.
Did he give you were still going to be a cop?
Yes,
Okay. But you just told me you're not in a badge position.
because I requested a non-badge position.
Okay, good. Just want to clarify that. Okay, what else did it say in this report, this recommendation for you? Why did he give, what reason did he give as to why he didn't want you to be a major crimes detective?
I had fallen behind on paperwork on some of my cases in 2019.
Okay, and how many cases was that?
I don't know the exact numbers.
Do you remember reading this recommendation?
5 years ago.
Okay. Would you like me to refresh you and let you look at it?
Apparently 11 cases out of 17.
Okay, and 11 cases out of 17 is what he says. And now, he didn't say they were for paperwork. What did he say they were for?
I didn't read that far. Investigated deficiency, I believe,
Yep.
was one of the words he used.
Well, did he say, these are two examples?
Yeah, I'm going to sustain the objection.
Okay.
I think we've
Okay.
gone within the bounds of what I allowed with respect
Okay.
to this area.
Okay. Well, being that you just read this, it wasn't over paperwork, correct?
It was over paperwork.
Okay.
And see, this is where it gets to be,
This is your honor.
You've been impeached. You've established the basis.
and he wants to keep the content of this report out, of course, but this is why it would be important for the foundation to be laid so he could recall her back to the stand and resume cross-examination in his own case once he gets this report in. But it's not about evidence tampering, it's about evidence mishandling.
I've made my decision. To strike his comments. Over the objection from the state, I allowed you to show her. I
Okay.
allowed you to
Okay.
talk and question her, but that's as far as
Okay.
I think the rules allow.
Okay. Did your boss discuss this with you at all?
No.
I'm sorry, he was major at the time, right? He's a lieutenant colonel now, right?
Yes.
Okay. Did Major Scabilia, did he talk to you about why you were being demoted? Or why he
No,
recommended
they
your
sent it
demotion?
to me in an email.
Okay, they sent it to you in an email?
Yes.
You didn't discuss it with you at all?
No.
So what he sent you is the document I have?
Yes.
Okay. And again, so that's not exactly voluntarily going down to dispatch, was it?
Being removed as a detective is not a demotion. A detective is just a deputy that works in a specialized unit. I was being moved to road patrol at the time.
That's a demotion, okay?
as I
Road
stepped
patrol
back
from detective to road
after being
patrol
major crimes for
is a demotion,
over 2
regardless of
years
how
and
she
the
wants
things
to,
that I had seen.
to make it.
And over the course of my law enforcement career, I knew for me, I couldn't do it anymore. So I voluntarily gave up my badge and gave up my job as a cop so I wouldn't have to see them things anymore.
So you're saying it had nothing to do with this recommendation from Shep Scabilia?
No,
Okay. And, you know, he never said that it was insufficient investigation.
Objection hearsay.
Sustained.
Okay. I'm asking if she ever heard that from her boss.
I know what you ask, and I sustained the objection. So
Okay. So in your mind, there was no reason other than you wanted to go down.
I'm sorry.
In your mind, there was no reason other than when you wanted to again, just switch departments. You didn't want to wear the badge.
Correct. I did not want to deal with the things that cops have to see.
Absolutely, Mads. That's exactly what she's doing. I mean, she's BSing, and she doesn't want to obviously admit on a national scale that she was, an incompetent police officer. But she was. She was an incompetent police officer who didn't follow the procedures of evidence, who didn't store evidence properly, and she, most importantly, was the individual that wrote out she wrote out the arrest warrant. She's the one where this case ran through. So if you can't trust what she did, if she wasn't following procedure, then the investigation that ran through her should be viewed in that light. And that report that he has should absolutely be able to be referenced and should be able to be brought in, because I got a feeling if they're successful in this motion in limine, they're going to try to keep it out from her being able to be questioned. So it's very important that he respond to this.
Did you ever see the results of those buccal swabs?
And now he's taking her through the different.
The results went to somebody else.
Correct.
Okay. And do you remember who that might be?
Probably Detective Pitcher, but I don't know.
Okay. And did you and Detective Pitcher, did you guys work together, or did you discuss everything about the investigation? I mean, were you working the case together?
In the first beginning of the case, yes. After the first week or so, no.
Okay, so could you tell me who was working the case after that first week or so?
Detective Pitcher,
By himself?
yes.
Okay. All right, just checking because I wanted to get the timeline here. Okay, so, you didn't get the results from those. You just collected the samples.
Yes, sir.
If I remember correctly, before the lunch break, and I could have them read it back for me, I'm not only asking because of time. Did you say, you never said that, you saw Travis in the truck? That you saw Travis sitting in the truck in the video?
That I said I never saw Travis.
All right. So, anyways, that was where the report was brought in. There may have been another time. I'd have to go back, go dig, and I will go dig and see what I can find more on this into the actual trial. In fact, it might inspire me to rewatch the entire trial, just trying to find all of the references to where evidence tampering was brought up in relationship to this document that the state has filed in the motion for limine, or in their motion in limine. And the idea here is they didn't. It was brought up in terms of trying to suggest there was mishandling. And what I'm concerned with here is this is the state's attempt to not have Malone cross-examined in this way like they did in the first trial. And again, this judge doesn't have to allow it, because he's going to say, well, no, you're correct, Mr. Tucker. It was excluded because you were alleging evidence tampering, and there was none. So it's very important. Like I said, these are the things that they did in the first trial. These are the little things that they filed several motion in limines beforehand, attempting to limit, attempting to keep things out, attempting to stop him from talking about certain things. But it is vitally important that these prosecutors be called out, that it becomes known, and that they see, look what these guys are trying to do. They want to keep, they have a man they know is innocent, a man they know is innocent of everything. Now, the other motions that they brought forth, again, like I said, if you look at the way they operate in a certain way. So we'll look through these. There's really not much on these. I'll just pull one up as an example. But they filed multiple motions just to have only specific testimony brought in. So let's go back to the Justice computer here real quick. Share this tab instead, and we'll go back in and take a look at this. Hold on here. Let me make sure I get this a little bit easier for you guys to read. So notice of intent to enter defendant's prior trial testimony comes down. This is an interesting motion. Comes down to state of Florida by and through the undersigned assistant state attorney, and files this notice of intent to enter in its case the chief in chief the defendant's trial testimony from January 23rd, 2024. During the previous trial, the defendant testified on January 24th. 2024. The state intends to enter the defendant's prior testimony during its case in chief in the upcoming retrial. At this time, the transcript of the defendant's testimony is not available. However, upon receipt, the state will submit the proposed testimony with the necessary redactions for the court and defendant's review. In order to avoid any unnecessary delays, the state requests the court to require that the defendant, within 10 days of receipt of the proposed testimony, to file any objections so the matter can be addressed by the court. Now, what I would say you have to do here is, obviously, we know what they're coming after. We know what they're trying to do in that instance. What they're trying to put forth is they want to go with this whole Paula deal where she sees the blood. But listen, Tucker needs to file a motion to ensure that if they're going to do that, then the entirety of his police statement needs to be brought in. So, in specifically the portion, which will then, specifically the portion that deals with what was stated to him by Phelps. So his entire police statement is going to have to come into can come into the case now. And like I said, it opens up a whole multitude of avenues that if the state wants to open this up, let's go. But the point is, the other thing that I would be asking is that, listen, you don't just get to put in a portion of it. The entirety of the testimony should be considered by the jury, and the state should be required to put that on in their case in chief. Again, something that you got to look at case law to make the request and find cases that support that position. But in my opinion, you've got to have context for the testimony, and you can't just cherry pick a little piece of what he has in there and not have the context of the entirety of the testimony. And that is fine. You want that in there? Then hear the entirety of Ty Tucker's testimony as it was presented there. Now, again, I'm not certain or familiar with how legal this is or isn't in terms of the fact that the defendant has the right to testify. So it should really only be available for impeachment purposes. But again, it's not something I've researched. It's not something that I've looked into deeper than just seeing these motions out. But this motion's interesting. Now, there's another motion in here, the state, I believe. That's the motion in limine. There it is. Okay. And they're already indicating as well, just so you know, we'll go over all the motions here. So here's another motion that they filed yesterday. Amended motion for trial transcription of Franklin Tucker and John Travis Johnson's testimony. Now, I want you to pay attention here because this is important when you look at how they tried to do their motion in limine. Comes down to the state of Florida and amends its previous request for the trial transcript. So they're amending their request. They don't want the entire transcript now in the above captioned case. It moves this honorable court for an order for the trial testimony of the defendant Franklin Tucker and witness John Travis Johnson to be transcribed for use in the upcoming retrial, currently set for May 13th, 2024. In support thereof, the state submits. 1, the state previously requested the entire proceedings be transcribed, but to be more cost efficient, the state requested the defendant and John Travis Johnson's testimony be transcribed as these transcripts are necessary for the upcoming retrial. The court previously inquired whether the audio version of the testimony would suffice. However, an actual transcript is necessary to abide with the rules of evidence as it pertains to either refreshing one's recollection or impeaching one's testimony. So what they're doing here is it's like, oh, is it a coincidence that they would file a motion in limine claiming things that didn't actually happen or were not actually said? And if they were said, they weren't captured by television cameras. And they file that motion in limine and then retract their motion to have the entirety of the transcript, the entire trial of the transcript produced before the next trial. Well, that kind of puts things at a disadvantage if that judge rules on that motion in limine prior to understanding what was actually said or wasn't said in the trial. And the fact that these prosecutors are simply saying rely on the assertion, that's crazy. You can't do that. You've got to have the trial transcript so that, if you're going to file a motion like that, and that's why the first thing Tucker needs to come back and say, first of all, before we can respond to this appropriately, it's alleged by me, number one, that was never said. Number two, we need to have a transcription. We need to have the entirety of the proceedings transcribed because it's impossible to know where this alleged statements were made since they're alleging it was stated over the course of the trial. There you have it. So we're getting the entire transcript. Secondly, there needs to be, the now for purposes of impeachment is one thing, but to be putting in as evidence, as a show of evidence, they could potentially use that, I guess, because he chose to testify in that previous trial. But again, this is where Mr. Tucker needs to get with his attorneys and advisors on pushing back on the motion to allow his testimony to be used, or if it is going to be used, at a very minimum, they should have to produce, as it part of their case in chief, they should have to produce the entire transcript, and the entirety of the testimony should be read to them. But I don't really, I've never heard of that ever happening in a trial. I'm not saying he couldn't. And again, it's something that I think is ripe for a researched issue. I haven't done that because I was just wanting to get this information out with what the state's doing and all of the questionable things that they're doing in this moment right now, because it's very questionable. This whole investigation should be placed before the jury. These kangaroo courts have been getting away with this kind of nonsense for far too long. I agree with you, Pamela. But the thing is, it can be. But this is why Mr. Tucker has to absolutely, without a doubt, make sure that he has assistance and help to make sure that it can competently and get in front of the jury, and do so, in a, following the procedures, because this judge has made it clear he's not going to, not tell you what you need to do, but he's going, but he's also saying you have a right to an attorney, you have a right to get counsel in here and help you and assist you with your case. If you choose not to have it, and then you further don't do or don't meet a deadline because it's taking too long or it's too overwhelming, then that's on you. So, anyways, guys, there was also a motion for intent to introduce Paula's testimony or her May testimony. So anyways, we know what they're going to do here, what they're going to try to do. Their case now, what they've done is they moved on. At one point, they were trying to do a jailhouse informant. Now they're just going to flat out come and lie to the jury. What they're going to try to do. So at this point right now, if I'm Tyrone Tucker, you've got to get in. It's got to be, and again, I'm not exactly sure off the top of my head what the procedure is to do it all, but I'm sure Tyrone can figure it out. But you got to get that police statement in, number one, or at least the portion of the statement that says, listen, if you're going to try to put in the portion of the testimony that deals with the alleged blood on the knife being Matt Bonnet's, then it should be allowed to go before the jury of exactly what was said by Tucker to Phelps, in terms of getting that statement into the court. Now, Detective Malone was in that room, so was Pitcher, so they can both testify as to the authenticity of that portion of the video that Tucker wants to put forth before the jury, but it should be allowed to come in, and it should be allowed to be played, and then let the jury decide, is that evidence of anything? Because it's not evidence of anything. There's that is evidence of nothing. They've got nothing here. You've got John Travis Johnson, who, great, let's get a transcript of his testimony. You know why they want, and I would fight that almost from the standpoint of suggesting that, and I would just put this in a motion and just oppose it, just for a simple fact of putting on a record that it appears the state knows that John Travis Johnson is lying and that he doesn't want to bolster. He wants to use it to keep track of his lies. And that's what he's trying to do, as opposed to, now you want it there because you want to be able to impeach him in case he changes anything. But I think the state really wants it because they want John Travis Johnson to read that. So first question I'm asking in cross-examination is, sir, were you provided or have you read your previous testimony in this case? Have you read previous reports in this case? And see what he says. And if he says, well, yeah, I was preparing. Okay. That's something the jury needs to know. But why would you need to do that? Why do you need to review the previous testimony when you should be testifying truthfully? And of course, testimony is supposed to be given as a recollection, and it's not supposed to be bolstered by previous statements or anything like that. You're supposed to come in, testify as to what you remember at that moment, and the jury is supposed to consider it from that particular standpoint. That's why you don't put in prior consistent statements like the state was attempting to slip in the last trial. But look, it's screaming right now that Ty Tucker has to get an attorney involved and needs to get his attorneys involved, and they need to get back in because they're going to try to do everything they can in this case at this point to try to be underhanded, dirty, and sneaky. And I don't believe it's going to go very well with this particular judge. It's going to be overwhelming for someone who's not an attorney to try to deal with the multitude of issues and the potential now that they have just literally laid the groundwork to fight this case and extend this case out. I know he's out on, but he's out on bond. But if they were to modify his house arrest and allow him to come off of the house arrest portion, well, guess what? Fight these things, man. We got to get, push back on the transcripts, push back on the idea. Like I said, we want a full hearing on all these on all these things here. The motion in limine can't be even dealt with until you have a transcript and allow the opportunity to go through the transcript in the state to bring forth as they should have. All they did was bring forth this alleged list. That's an incomplete motion. It should be thrown out for that. For the fact that they didn't bring in they have not proven the statements were actually made. So that would be the first thing. Is there's been no proof that those statements were even made. I'm contesting the fact that they were. I'm contesting that it was ever stated. It was stated that they were mishandled. So, Judge, how do you solve this? The only way you solve this, full transcript. Thank you, Mr. Mansfeld and company. So we wait for the transcript. And then we have a hearing on it. And then when it becomes clear, this judge will be able to get to know this prosecution team. And these are the things that you got to do. Because if you don't do that and you roll forward and you go, well, I'm going to run in and go before the jury, this judge is a no-nonsense judge. I think he's fair, but we'll see how fair he is. And he needs to be tested for things like this. Anyways, I think Ty Tucker goes live tonight at 8 p.m. Eastern time, 5 p.m. I'll be interested to hear what he has to say about this and all of this. We knew there was going to be things coming out. We knew they were going to be trying things. We know the Paula Belmont knife testimony is going to play a big factor because they have no evidence. So they're going to try to put that forth. But that's easily contradicted, and you should be easily prepared for it. And then on top of that, you got John Travis Johnson. Well, now we attack John Travis Johnson. We attack him with Todd O'Quinn. We attack him with the fact that Todd O'Quinn, that there are statements there. And again, what I want to see out of Tyrone Tucker is when he's questioning John Travis Johnson, he needs to load up those questions and he needs to say, can you explain, sir, why Todd O'Quinn told the police that he saw someone resembling you at the scene? Can you explain, sir, why there was an individual seen running, getting into a truck at the scene? And you know what? Let them object. The whole purpose, and this would be if Tyrone Tucker is representing himself. That is what you're there to do. Screw motion in limines, screw all of that stuff. What the hell are they going to do to you? They can't take away your bar license. They can't take away any of that stuff. You got to load up the questions. You're in there fighting for your life, and they can't do anything worse than what they're going to do if this jury turns against you. So you need to go in there, load up those questions, have a list of them, and let them take you to the sidebar 100 times. Have old Mansfield jumping up so much that he loses 20 pounds. It'll help him out and help his heart out because he'll be jumping up and down and screaming, and turn that courtroom upside down. That's what you got to do if you're going to represent yourself in this case and get as much stuff before the jury as you can. Now, obviously, I guess they could hold him in contempt and revoke his bond or whatever the hell they could try to do. But at the same point, you're going to be bringing all these things out. And then you're going to get Todd O'Quinn in and you reference that. And if he needs to wait, I mean, obviously procedurally, the best thing to do would be this, right? The procedural way to do the proper cross-examination is you get Johnson on the stand, you question him about things you can question him about. Then you, in the case in chief, the defense's case in chief, you put on Todd O'Quinn and have Todd O'Quinn go over the fact that, yes, he saw someone resembling Travis Johnson, that he did, in fact, tell Detective Pitcher that on that day. Now you call Travis Johnson back up on the stand and you say, can you explain, John Travis Johnson, why Todd O'Quinn says he saw you at the scene? Can you explain this? Can you explain that? And you know what? The state might say you can't ask those questions. But you know what? Let them. Then the jury really will be wondering what the hell's going on here. You got Todd O'Quinn saying he saw a guy go jump in a truck and get the hell out of there. You've got Paula Belmont's testimony that will come in that will hopefully say, hey, she's that will essentially say, hey, he she didn't know who the second person was. And then most importantly, now the one thing that's sad that can't get in is you really want that information in. And I don't know if it was in the deposition or not, but you really want those initial statements in from Paula Belmont, which would have been great to have brought up and said, did you hear, did you tell, or did you, because see, one way you can get prior statements in if they're inconsistent. So one method of getting things in is you can come in and say, tell us what you heard. Okay, I didn't hear this. Well, did you or did you not tell detective or tell so and so that you heard a truck on this date? Well, if we play this, or I'll provide you with a transcript, but that refresh your memory, and explain to the jury. And then it says, well, that does refresh my memory. I did, but that's relevant information that she hears a truck, a car, or something start up after the individual that was not Rory Wilson run out of the scene. And then you have Todd O'Quinn. Hey, sees a guy get into a truck and take off, take off in a truck, pulling off the mask, poofy hair, looks like John Travis Johnson. He identifies John Travis Johnson at the scene. Now let the state come up and bring up all the impeachment. To hell with it. Who cares, right? But you got this guy, but you got O'Quinn up. And then you got Roger Rugged, and you got to go harder in on him and say, listen, were you able to identify him? No. You certainly don't want to, you could ask about, let them ask about height questions and things of that nature. But you just established with Roger Rugged, you didn't know who it was. Did you hear a voice? No, you didn't. Did you see who they were? No. Did you see the person with a beard? Did you see a Jägermeister? Whatchamacallit? Now maybe he comes back and says, yes, there was a Jägermeister Gator, but he's never said that before. So then you can impeach him. And that's what that's got to be the entirety of this case. But again, if he's going to represent himself, he's got to go completely out with it. He's got to go crazy in the courtroom, and he's got to just go nuts, because this is a fight for his life. So he doesn't have any procedure. There isn't procedure when your life is on the line, and in the rogue state of Florida is attempting to try to do everything dirty they can do. So you got to get dirtier, you got to get crazier, and you got to let them know, listen, I'm going to bring it all in one way or another. That's why I don't have attorneys here. Now, if you want to follow a procedure and you want to do all of that and you want to make an argument, like I think there's a very strong argument that they don't have proof beyond a reasonable doubt and that this case deserves a not guilty verdict, bring your attorneys in and let them get to certain pieces of evidence that can come in. Let them get the things in that they want to get in that can impeach the witnesses and that can raise doubt as to the validity of the case, and let them bring in impeachment material. Let them bring in the motion for Seth LeVay, the motion to suppress, and get that properly in front of the jury. And I mean, by the time you play the interrogation video, which destroys the whole blood on a knife theory, and then you get to Seth LeVay motion to suppress, and you put that before the jury, and you are able to impeach John Travis Johnson with that, and then you get Todd O'Quinn saying he saw John Travis Johnson get in the truck and take off, or says some variation of that, but at least says he sees someone resembling John Travis Johnson. This case is done. But the point is, it's got to be addressed. It's got to be addressed what the state is doing here, and the state cannot get away with pulling stuff like this. They cannot openly lie to the court, claim things that didn't happen, and try to continue this cover up. They need to put up or shut up. They need to show that they have evidence in a case. And again, the motion to dismiss will be a great opportunity to take the temperature of this judge and see what this judge does. And maybe it never makes it to trial, but Tyrone Tucker's got to be prepared. He's got to get responses in on all of this. And again, with the amount of things that he's got to handle here, the amount of opportunities that it has, like I said, this is a great time to get in and let the attorneys come back in and handle and address these motions. But again, but there's always the possibility, of course, too, that maybe the attorneys don't see things the way I'm seeing them, or don't see things the way Tyrone does. But if he stays in the case as a pro se defendant, then he's got to address these issues, address these motions. He's got to get on top of it. He's got to go find case law, or at least utilize these attorneys to try to find case law on the need for, if there is a conflict of thing. In other words, if the state is alleging certain things occurred in trial, and the defendant in response to that motion is saying it's flat out not true, how do you rectify that? You can't rectify that without getting a transcript. I don't even know if you need case law on it. I think it's pretty obvious, but you won't want to always have cases to bolster your opinion. Secondly, he needs to file a motion in a response, essentially stating that, again, he responds back saying that no, we want I guess he could be responding to all of the transcription motions, say, no, we want full transcripts for this reason. But also, send back something in line to questioning, well, why is it that, what purpose do they want? What purpose would you want to have John Travis Johnson's testimony for? And that's why I would object to that we object to having John Travis Johnson's testimony transcribed. For what purpose other than to make sure that your witness, who's obviously lying, who was proven to be a liar in the first case, that you want to make sure his testimony stays in line with what he was talking about, because you got a guy who's actively out, probably, using substances and stuff, and his memory's probably not great. And that's what they're probably worried about. And then you're going to have conflicts with the testimony and conflicts with police statements. So again, there's something there. And then they did another interesting deal where they want to use Google Earth images and put that before the jury as evidence. And again, I would say no, because you got to verify that the Google Earth images, first of all, are they representative of what it looked like back in 2017? And they haven't shown that. So you don't just get to send images before a jury. There, you gotta fight back on that motion as well. And again, say, listen, they've got to show that what they're trying to do with this, and they've got to show that it's actually matches what the scenes look like back in 2017. You can't put something up. There could be buildings built. There could be traffic lights in effect. You don't just get to put a Google Earth image and say, oh, we're going to put it up. You can put a map up. You can put a map up from 2017 and show the jury, but you can't be showing Google Earth images that you don't know. Are they from 2017? Are they from 2024? I don't believe the motion doesn't even state that. But anyways, that's what we're dealing with here, guys. Get this information out. Share it with the public. Share it, share it where you can. Like this video as well to try to keep it so that people can see this, because this is the stuff we're going to be bringing light to leading up to the retrial of Tyrone Tucker, if it makes it that far. And we're going to be putting it forth. I'm going to be sharing it with my viewership and sharing it with with everyone. And if all 12,000 of you share this video, it can get out to thousands and thousands and thousands and thousands and thousands of people, and maybe get the eye of somebody like Vinnie Politan, who can jump in and really take this to a national level, or someone like Jake Tapper, who we know was advocating for another person that was wrongfully accused. Somebody who cares, who's got a big media footprint, and can really put this case in the national spotlight. And that, I can assure you, Mr. Ward, who you see there in the center, being up for re-election, will give him pause in how he proceeds. So anyways, guys, I'll leave you with that. Thank you for tuning in. Like I said, it's an impromptu live. I'm going to continue to review the record and see what I can find. If I find any instances where the reference is made to evidence tampering versus evidence mishandling, and we'll find out and see if I find it. If I do, of course, I'll be, we'll bring it forth and we'll talk about it some more. So from there, guys, I don't see any other questions in chat. So if I don't have any questions, I'll give it about 30 seconds. Any questions, come forth. Otherwise, we're going to end the live. I appreciate everybody watching, and I'll talk to you soon. So let's see here. Let's go into my. All right. So I think we're going to call it, guys. I appreciate it. I appreciate everybody that watched. And like I said, like, share, and get this video out. And let's keep fighting. Good fight for Franklin Tucker. Keeping what they're doing here, and not letting corruption survive, or not letting corruption run wild in darkness. Anyways, guys, talk to you soon. And until then, let justice prevail.